Here, who's going to help us with the discussion on the Citizens United case and what it means kind of nowadays and potentially what it could mean in the future. But before we get started, who knows more or less what the Citizens United case is about? More or less, maybe? Okay, so it's not completely foreign to most of you. Some of you may have heard of it before. So we're going to give you kind of a brief overview as to what it is. I'm going to try my best to kind of tell you how we got to Citizens United, what the beef was, and then Professor Sanders is going to be helping fill in some of these holes that I may potentially be missing. After that, as you can see on your tables, there's some discussion questions. I'll give you a second for just you to look at them and to think about them and digest them for a second. And then Professor Sanders is going to give us her insight on them, and then we'll open it up for everybody else to see kind of what they think about it. And a lot of these are just kind of projection questions. Where do you think Citizens United is going to take us later on? So Citizens United. Citizens United is a group, a nonprofit group that does quite a lot of other things. But just to kind of cut to the chase as to what they were fighting about is that in 2002, the Bipartisan Campaign and Reform Act was passed. And it kind of changed the game as to how election and election expenditures and investments took place. The biggest fight was about Section 203, which prohibited corporations and unions from electioneering communications within 30 days before a primary or 60 days before a general election. And so we'll go into what electioneering communication really means, but for now, that's all you need to know. So, in 2004, so 2 years after this law passed, Citizens United filed the complaints against the Federal Election Commission, the FEC, because Michael Moore put this movie together called Fahrenheit 9/11. And so they're like, oh, well, this movie is a political expenditure, and it's within the time frame that this statute tried to prohibit, therefore it's a violation of the statute. And so the court ruled like, no, Fahrenheit 9/11 has nothing to do with politics. It's really a movie for financial reasons. So like the reasons that the movie production's putting together wasn't for any sort of political gain. It was just to make some money. That's how the court interpreted it. So they're like, wrong, you're out. And so Citizens United was like, well, all you need to do is be a bona fide movie maker, and then you can make movies about whatever you want, whenever you want. I'm on that, son. And so they started making a whole bunch of like movies here and there. And eventually, the next presidential election came by, and they made this movie called Hillary the Movie. And Hillary the Movie was about then Senator Hillary Clinton, and it was very critical of her. And so they wanted to put this movie out like on cable TV. And they said, no, you can't do that. That is electioneering communication based on the statute, because you're doing it for political reasons. You're not really doing it to make money like the Fahrenheit 9/11 movie. And that's kind of where the whole beef started. That's kind of where Citizens United was like, well, no, then that's really unfair compared to how you treated the other movie. And this rule's kind of unfair to begin with. So we're going to take you to court. And so that's generally how Citizens United got to the Supreme Court. So right before I let you know how the Supreme Court decided, I'll let you know what the parameters of the law was at that time. The two biggest cases that the Supreme Court leaned on was Buckley versus Vallejo and another case called Austin versus Michigan. So I'll let you know the generalities of those two cases. What Buckley versus Vallejo said, in that case, there was another law. This was a law or a case from 1976, so way before Citizens United. And they tried to control the expenditures and contributions to political campaigns. At that time, the federal government felt like it was getting out of hand, and they tried to regulate it. And so they tried to regulate the amount of expenditures that political campaigns can have. And at that time, they said, no, because in order to disseminate speech, you need to spend money to say what you want to do, either through advertisements, through posting things on newspapers, on TV. In order to say what you want to say, all that costs money. And if you're not allowed to spend money, then in turn, you're not allowed to say anything. So that was the beginning of where money equaled speech. that's kind of the nexus that they try to form, and that's what Citizens United was trying to say. In Austin, that case was from 1990, and so the Buckley case, the Buckley case really talked about money and what that means to speech, regardless of corporations. They didn't really touch so much on the corporation issue. What the Austin versus Michigan case did was that that case started challenging a law that prohibited corporations from spending a lot of money on political campaigns. And they said, no, if we allow corporations to do all this, then they're going to take over the political game. All of the views are going to be really distorted. And it's just going to be a mess. So no, corporations aren't allowed to do that. So these are the confines of the law that Citizens United was facing into. So within these confines, the Supreme Court had a couple decisions to make and try to figure out what to do. If they wanted to take the side of Citizens United and say, yeah, you can't restrain this kind of disseminating of money for speech purposes as applied to corporations, that's going to overturn the Michigan case, because the Michigan case was so focused on what corporations, large corporations, could do to distorting people's minds in the political game. That's what the Michigan case was really focusing on. And so now it's time for, when Citizens United came along, the court wanted to revisit that. So the court, it was a very split decision, and there was a lot of opinions, a lot of concurring opinions, a lot of dissenting opinions. And in a 5-4 decision, the court said that the Section 203 of the Bipartisan Campaign Reform Act violated the First Amendment. And so what they did is that they took the portion of Buckley that said money equals speech, because you need to spend money to say what you want to do, essentially. They took that chunk of it and said, okay. Then they took the chunk of the Michigan case and said, well, speech is really about the speech itself, not who says it. And one of the very important quotes that's very criticized by a lot of people is that the court said, more speech is better than none. So in the Michigan case, they were like, well, maybe corporations want to give out a whole bunch of stuff and they might distort the views of people. But we should allow that, because people are allowed to make up their minds and they can figure out what's right and what's wrong. Who are we to say like that Coke is endorsing this politician and therefore that's distorted? We're no one to say that. If that way we're controlling speech and we're controlling people's minds. That's what they were concerned about. So they were like, you know what? Nah, we're not going to do that. That's to us stepping too close to that line. And if we start controlling this speech from corporations, are we going to start controlling media corporations? Are we going to start controlling blogs? Like I can't go on Tumblr and talk about how Barack Obama sucks or Mitt Romney sucks or whatever, because that's a corporation. And so they started kind of focusing on this domino effect, right? And so as soon as they grasp onto that nexus of like speech protects, or excuse me, the First Amendment protects speech, not the speaker, they grabbed that and they started throwing it against corporations. They're like, well, it doesn't matter who says it as long as the speech is there. And it's up to you to figure out whether you're listening to some bullshit by corporations or is the real deal. We're not gonna, that's what the Michigan case tried to protect you from, and we're gonna take away that protection from you, and it's up to you to decide. That's what Citizens United started doing. And so it said, no, that is unconstitutional against the First Amendment, and therefore you can't ban us to whether it's 30 days, 60 days, 1 day, you can't ban corporations from spending money to say what they want to say about any political figure. So this is where we are now. It upheld other parts of the Vicar law, like if you're giving money to actual campaigns, you know, there's a bunch of restrictions on that, because that's not spending money, which is speech, as it was established in the public. Spending money is speech. Contributing money to a politician, that is less. They didn't count that as speech so much. And we're not going to get into that analysis whether we're right or wrong, because that's a whole source of jurisprudence, theoretical framework that I can't even ninja my way to. So, and if I can't do it, no, not. So this is where we are. And so what does that mean now?